Hi, everyone. Thank you so much for being here for Milgram and Dascom's second of 3 legal sessions on business foundations. My name is Amanda Milgram. I am a litigation partner at Milgram and Dascom, and I'm here with my colleague, Jason Fisher. And we are here to talk to you today about third-party contracts and specifically some more obscure, undiscussed provisions that you may just gloss over in your contracts, and we're hoping to shed some light on them and give you guys a little better sense of what to be looking for and what you're reading. But before we get started, let's do a shout out to our sponsors, Capital One Cafe, Dell for Startups, the Downtown Denver Partnership, and the Denver Business Journal. Thank you so much for making this possible. This session is part of the designer track, sponsored by the Public Works and Battery 621. And also thank you so much to Greenspoon Martyr, who are hosting us today. If you scan the QR code up here, I think they're giving out prizes and other stuff, so check that out. Should be pretty cool. A few more sponsors. Thanks, everyone. And lastly, we're a law firm, so we have to give this disclaimer. This is not legal advice. We are not creating an attorney-client relationship. Happy to do so later if you guys want to chat separately. But for now, this is just us up here giving you guys information that we know. So, Jason, take it away.
All right. Well, thank you so much. As she mentioned, my name is Jason Fisher. I'm a lawyer with Milgram and Dascom. I specialize mainly in corporate law as well as I dabble in employment. So I handle a lot of contracts, whether I'm drafting them or reviewing them. And today we are going to be discussing just some of the, I think, more difficult to understand or more complex, more nuanced provisions that you will typically see in your agreements. And the sort of agreements that these are in, it's a wide variety of them, but the ones that you're likely to come across are your co-manufacturing agreements where you're engaging somebody to produce a good for you, your development agreements where you're engaging a designer to produce a website or an application or something of that nature. So that's kind of how we've tailored this. We have limited time, so we initially wanted to kind of walk through an entire agreement with you, but today we're going to focus on just these 5 provisions that you're going to see and that are typically misunderstood. So those are restrictive covenants, assignment of work product, insurance, indemnification, and limitation of liability. And so these are all very legal terms. They're not those business terms that generally you can understand, right? Who's going to do what for how much money? Those things are sort of understandable. Here, these are provisions that show up typically on the 3rd or 4th pages of agreements and that are just generally not well understood. So we're going to jump in here with restrictive covenants. And restrictive covenants, the 2 kind of flavors that these come in that you more commonly refer to them as is non-competes, non-solicits. So there's a lot of regulation of non-competes and non-solicits, particularly in Colorado. In Colorado, the law just changed last year. So there's only specific circumstances where these types of provisions are going to be enforceable. The big thing to keep an eye out for in Colorado is that they implemented salary thresholds. So for a non-compete to be enforceable against an employee or a contractor, that person has to be making $112,500 per year. That number is indexed to increase year after year, so it keeps going up. Next year, it will go up again. For non-solicits, it's 60% of that threshold, so 67,000. And again, it's indexed to increase. Generally, when you are reviewing a non-compete or non-solicit, you want to look at the scope of the non-solicit to determine its enforceability. So it has to be limited in the amount of time, the length of time that somebody's going to be restricted from taking an action, the geographic area in which they can operate. So, if you're in Colorado, it might be the state of Colorado, it might be the Denver metro area, it might be the whole US in certain situations. But the broader it gets, the less likely or the more difficult it becomes to enforce. And then in kind of the industry or business that it is in. So what they're going to be restricted from doing has to be kind of directly tied to what they have done for you. And so we are going to flip to this next slide and kind of run through a typical battery of these provisions. So you'll see up top here, non-solicitations come in 2 different flavors. You first have a non-solicitation of employees. These provisions are not regulated hardly at all. So this is really about poaching employees. If you leave a company, you typically can't take employees with you if you have this provision in there. The ones that are heavily regulated is going to be the non-solicitation of customers that has that $67,000 per year salary threshold. And what that is saying is that this person is engaged with our company in a way that exposes them to a lot of our trade secrets, a lot of our important information and secret sauce that if they were to take that out into the job market and use that however they saw fit, it would give them an unfair competitive advantage. And so we were going to restrict them from taking our customers after they leave our business. A non-competition does a similar thing, except it's a bit broader in that it simply says they're not going to be able to compete with us in this industry for a given period of time. And you'll see here in this example, the time period is a year. Enforceable non-competes range, from I think probably like 6 months to 3 years on the outside. Sometimes there's a 5-year one that is enforceable, but the trend is away from these provisions. Courts really don't like them. They are relatively friendly to employees and contractors that are trying to fight against them. And then again, the FTC, I believe it is, has a proposed rulemaking that would ban them entirely. So a lot of development in this area, a lot to be seen of kind of where this goes. And then jumping around here a bit to assignment of work product. And again, this is important when you are engaging employees or contractors because you want to be sure that you own whatever it is that they're creating. And so for employees, how this happens is work made for hire. There is a statute that says that if an employee creates something in the course of their employment duties, it is automatically transferred and assigned to the company that they're performing that for. For contractors, that work made for hire is not obligatory. It has to be written into the agreement. So you'll want to look and see if you are hiring a contractor whether the assignment is a work made for hire assignment. Typically what you'll see in a contractor agreement is both, where you'll have work made for hire as well as a present assignment. And so jumping back up to that first line there, the difference between a present assignment and a future assignment. And so if you are hiring somebody to perform work for you, what you really want to see is a present assignment of their work product. That's typically signaled by a hereby phrase. The person hereby transfers and assigns to X, Y, and Z company their work product. If it's not a present assignment, there has to be some future events that occur that would cause that assignment to happen. And this is sort of dangerous because if those events don't happen, the company could end up not owning that IP. Or it could be that those events do happen, but you also need to have a follow-up written agreement saying that no, this IP actually is signed. So we typically always look for present assignments when we are representing a company that's hiring a contractor to produce something for them. Some of the other provisions that affect assignment of work product are the bottom 4 bullets there. So further assurances is one that you will typically see and something that you generally do want to see if you are the party that's hiring a contractor. What further assurances does is it says that if there are those other agreements that need to be signed in order to demonstrate that the IP has actually transferred, so say down the road you need to make a filing with the Patent and Trademark Office to indicate that you own a trademark or some type of copyright. You want to have the party that created that obligated to sign whatever document you send over to them. So it could be a 1-page simple assignment document that says, no, I actually did assign the rights to X, Y, and Z to this company. They do own it. So the further assurance clause is going to require them to do so. The power of attorney kind of goes together with a further assurances clause where it's also saying that they're going to sign, but if they don't, we have power of attorney to sign on their behalf. And this is important because you may hire a contractor to produce something for you. They deliver that work 2-3 years down the road. You need to demonstrate ownership of that work. You can't find that contractor. They've gone out of business. You don't know where they are. If you have the power of attorney, after some reasonable diligence of looking for them, trying to get them to sign, you can just sign on their behalf, and that's going to give you the right to continue moving forward. Power of attorneys, generally what you want to look for is that they are coupled with an interest. That means that if that person suffers an incapacity, the power of attorney still remains in effect. So just some small nuances there that you want to keep an eye out for. Moral rights, I think, is a very interesting provision. It kind of arose from this old legal concept that artists have certain rights in their work after they've sold it even. So the classic example here is that an artist paints a beautiful painting. He sells that to a buyer, and that buyer wants to take it into the town square and just utterly destroy it, just tear it apart in front of everybody. If that artist still has moral rights in that painting, they can restrict the buyer from doing so. They can say, no, you can't destroy my work. You have to display it somewhere. You have to use it as you typically would a painting. If you are a company hiring a contractor, you want to be able to do whatever you want with the work that they create. And so we want to see them waive those rights, those moral rights. And then licensing and license back. Important to know what rights the creator, the contractor, the employee, whoever it may be, is retaining in the work that they produce. So they're transferring ownership to you, but do they have any right to use that in the future? In further projects they do for other clients, things of that nature. Typically what we want to see if we are a company hiring a contractor is that they are not getting a license to use that. They've produced this work solely for us, and they're transferring everything to us so that we can use it. And if they want to do something similar for another client in the future, they have to do something different. All right. And I know this is a huge information dump. There will be lots of time for questions at the end, and we can come back to these as well, so I appreciate that. And then we'll talk briefly about insurance. And insurance is an important provision. It's one that a lot of small businesses struggle with. When you see an insurance requirement, whether you are requiring somebody to get insurance or more typically for a small business, another party is going to require you to have insurance of various kinds. And so you want to look at the policy types and the policy limits. Obviously, these are kind of stated up front: general liability of X amount, workers' comp of X amount, yada, yada, yada. And you want to look at those, and this is, in my experience, a very negotiable provision. So when you see policy limits that maybe are very high and you talk to your insurance provider and it's going to cost you a large sum of money to go out and get that kind of insurance, oftentimes you can work with your insurance agent, tell them what you're doing exactly, and they can suggest some more feasible insurance requirements for you. You can take those to the party you're negotiating with and kind of say, hey, the insurance agent says this is probably enough, and generally that's acceptable. So very negotiable, very important to kind of pay attention to those. The other items that you want to look for when you are reviewing an insurance kind of provision and requirement is the length of time that you're going to be required to maintain that insurance. So insurance provisions typically have a tail, meaning that you're required to maintain that insurance for the duration of the contract, and then a period of years after the contract expires or terminates. The types of insurers, so generally or oftentimes people require you not to have just any old insurer, but some kind of rating, an AM Best rated insurer is going to be providing these things. So you want to make sure that your insurance qualifies for what they are asking for. And you want to make sure, because they are often going to ask for a certificate of insurance that is going to evidence the coverage. And if you can't provide that, you're going to be in breach of the agreement, which is obviously what we always want to avoid. On the certificate of insurance, and these are some additional requirements that are often going to come into play, additional insured. So generally the party that is requesting insurance wants to be listed on your insurance as an additional insured so that they can be covered directly under it. That's something that you have to negotiate with your insurer, and that has to be evidenced on your certificate of insurance. Waivers of subrogation is another one that is beneficial to the party that is kind of asking for insurance. And what this is saying is that a waiver of subrogation is that the insurance company, if there comes to be an event where insurance is needed, the insurance company isn't going to go after any party for negligence. They're not going to sue that party to try and recover some losses because they acted potentially negligently. And then notice requirements. If you are going to change your insurance, you want to make sure that you go back through your contract and check to be sure whether or not you need to notify those parties before you do so. Again, all just trying to avoid breach in those situations.
Thanks, Chico.
Oh, and then I'm going to pass it over to Amanda. She's going to talk about the other provisions there.
Thank you. Great point. And just on the insurance from a litigator's perspective, I just want to point out most insurance companies are going to require you to give them, they're going to have a window of time when you can give them notice of a claim. So the minute that you as a business owner are aware that there might be a dispute, it doesn't mean a lawsuit was filed against you, but you might get a cease and desist, you might get a demand letter. Immediately report that to your insurance company. I can't tell you how many clients I have had who fail to do that and then are not able to take advantage of the benefit of having insurance to cover their defense because they reported it too late. So just always report it. You don't have to use it. You can tell them, I'm not sure if this is going to result in anything yet, but wanted to make you aware. Okay, turning to indemnification. It's a very boring provision. People hate it. Nobody gets it, even lawyers. I'm going to do my best to break it down so at least when you see it in your contracts, you're going to understand what you're looking at and have a sense to know what you might want. So what is indemnification? Indemnification is where one party, we're going to call them the indemnifying party, takes on the obligation to pay for any loss or damage that has been or might be incurred by another party. We're going to call them the indemnified party. Typically, this stems from third-party claims. So I think it's really helpful to look at this in an example rather than talk about it in these amorphous terms. So let's assume Jason and I enter a contract. I make widgets, Jason's going to buy my widgets, and he's going to sell them in his retail store. Okay, I make the widgets, I deliver them to the store, he puts them out in his retail, a customer comes in, they buy the widget, they take it home, they get injured by the widget. Customer sues Jason. Who thinks it's fair for Jason to have to cover all the costs, the legal defense, and pay the consumer to fix them? Anyone? Not really. He didn't have any control over how that widget was made, right? He doesn't know what happened. He gave me a sum of money, assumed that I did a great job, that's why he contracted with me, and off he went and sold it. So he's gonna turn to me and say, hey, Amanda, come indemnify me. You're responsible for covering all of this. That's what an indemnification provision does. It allows the parties to customize the amount of risk and exposure they have and allows them to shift that risk to the party that makes more sense to cover it. Next slide, please. So indemnification provisions are not all-encompassing. They're not going to cover every claim and every type of damage you've ever are going to see. They're typically going to be types of damages they cover and types of claims they cover. So we're just going to talk about those really quickly again so you have a sense of what you're looking for and how you might be able to use these provisions down the road. First, it's going to be limited to recoverable damages. These will specifically be listed in your indemnification clause. So these are the types of things you want to read, and these are the things you're going to be negotiating for with the other party. There's very common covered events, and these are the things like a breach of contract, negligence, bodily injury, or non-compliance with laws. Again, a lot of the time it's because the person who created the widget has control over those things, whereas the person purchasing the widget does not. So he's going to shift the risk over. We're also going to see different types of damages being covered. These might be losses. These are things like judgment, settlement. So let's say Jason and customer reach a settlement agreement over the damages that customer incurred. He'll turn to me and say, okay, Amanda, please pay me that amount of settlement. You're also going to see things like liabilities or debts and also just judgments or claims. If it does go to litigation and goes all the way, I would then be liable to pay for his attorney's fees, costs, and whatever monetary judgment comes out at the end. There are some exceptions from indemnification that you're really never going to see. And these tend to be items where it's the indemnified party's own action. So if Jason takes the product and he throws it on the floor first and then he goes and sells it, it's not really fair for then me to have to indemnify him, right? Because he used it in a way that it wasn't meant to be used. So those are the types of things that will be carved out. Finally, we're going to talk about limitation of liability. Kind of goes hand in hand with indemnification. This is a provision you'll also see typically way at the end of your contracts. By then your eyes are glazed over. It's all gotten really boring. I get it. As a lawyer, I even feel that way. But limitations of liability, these are going to limit your exposure that you face as a company in the event of a claim or a lawsuit against you. It's also going to cap the level of damages that you would be expected to pay. It provides certainty. I mean, why do we like a limitation on liability? As I'm sure many of you know, litigation can be extremely costly. The damages can be astronomical. The limitation of liability allows the parties coming together on the front end to contract for what kind of damages are going to be permitted and lower the risk for everyone. We typically have two types of ways that we can limit liability. There's going to be a waiver of damages and then a liability cap. The waiver of damages is going to limit the type of damages that you can receive. Typically, only direct damages. So what are direct damages? These are the type that logically follow a breach of the contract. So for example, let's come back to I sell Jason a widget. Jason goes out and sells it to the customer. Or let's do a better example. Let's say I'm going to sell him a widget. He thinks I'm delivering them today. We have that in the contract. Today's the day it's going to be delivered, but I don't. Okay, I've now breached the contract. Jason is going to have damages directly resulting from that breach of not delivering them. They're reasonably foreseeable. Those will be allowed. What would not be allowed under that contract, under that limitation of liability, is perhaps that because I deliver them a day late, he has to open up his warehouse another day. There's cost in electricity. There's cost to labor, bringing his employees in to work that day. Those are indirect damages. They're not foreseeable. They're much more speculative, harder to determine the amount. So those are going to be excluded. So again, we're limiting the damages to what is reasonably foreseeable between the parties. You're also going to see liability caps, which is going to place a max cap on how much money you will pay. And there's typically 3 ways that a limitation of liability clause will do that. The first is the contract's value. The second is the amount the insurance will cover. And the third is just a sum certain, an amount that the parties agree on the front end. So, for example, same situation. Well, let's use a different example. I think this one's easier with services. So let's talk about, now let's imagine I'm giving Jason social media consulting, and he pays me for 5 hours a month of work. I think that's common for a lot of businesses these days, right? You don't have in-house branding people, but you've contracted out for someone. If he pays me $1,000 a month for my 5 hours, we might cap the damages at 12 months, so $12,000, right? And no matter what, I'm not gonna have to pay him more than that. It's a very common way you see these liability caps work. There are typical exclusions that you will not see covered under a limitation of liability, and these are things like the indemnification obligations that we already talked about, breaches of confidentiality, breaches or misappropriation of IP. Those types of things, the damages can be so much higher and so much more catastrophic to the business, doesn't really make sense to cap them here. Sure, go ahead, that's fine.
Okay, just on the liability cap, actually, my question is typically in a contract which involves IP mainly, what is the kind of cap that you see in the service agreement and also in an NDA which is signed prior?
Okay, so the question is in an IP agreement,
Yeah.
what kind of caps are you going to see, and also in an NDA?
What you typically see, because the NDA is normally signed first off prior to the services agreement.
Yep. So with an NDA, I don't think you're typically going to see a limitation of liability included. And an NDA is a non-disclosure agreement, for those of you who don't know the acronyms. And that's often happening with 2 companies are coming together before they've entered into an agreement to work together, but they're going to share confidential information with one another. They're each going to sign an NDA. Depending on which way the information is going, it may be one way, it may be both ways. That allows them to see information, to decide if they want to work together in the first place or not, and allows them to prohibit folks from going out and sharing that information. So you're not going to see a limitation of liability there, because really the only way to breach that is you've gone out, you've stolen their confidential information and used it or sold it. So we're not going to typically see a cap on that type of thing. Great question.
No, but if the service agreement is connected to the NDA that you're signing, then are you saying that
Oh, I see. So
limitation in the service agreement as well?
you might see one in the service agreement, but it's not going to be capping damages on the misappropriation of the IP.
Yep.
That is going to be carved out. So if we look at the next slide, actually this might help. You're always going to see a limitation of liability clause in capital letters, which makes it even harder to read. Thanks, lawyers. This is in part to make sure that it draws your eye. They're trying to make sure you read it, although I think it tends to make people not read it, but makes it more enforceable in court if you have it this way. So what you can see here in section 1, in section A, you actually see the exception right up front, except for liability for breach of confidentiality or infringement of misappropriation of IP. So again, like front and center, right away, they're carving out these items. As we go down here, now you're seeing they're capping the type of damages. So you're not going to be liable for consequential, indirect, incidental. Those are all the unforeseeable damage that could occur. And then in section B, Again, you've got the exception right at the front, very clear what's not being covered, and then they're diving into what's the cap on damages. And here they're doing 12 months value of the contract. So finally, some steps to avoid litigation when you're negotiating your contracts. Please read your contracts. I know that sounds really silly, but I can't tell you how many clients I've had who get into really bad legal disputes because they didn't read what they were signing. It does not work to walk into court and tell the judge you didn't read it, so you didn't know. They will laugh at you. They don't care. So please, I think so much would be resolved if we all just read our contracts. I know I'm guilty of it. Lawyers are guilty of it all the time, but do try to read your contracts before you sign them. There's also a couple other steps you can take. So anticipate and address worst case scenarios. I think as humans, we tend to want to just look at the bright side of things and talk about what can happen if everything goes great and wonderful. But it's really important that you talk about what happens if things go wrong, and you set your expectations out ahead of time and talk through them together. Make sure they're written out in your contract. And this goes to number 2, leave nothing to chance. Define as many terms and procedures as possible. What happens if you want to terminate the contract early? How do you do that? Is there a notice period? Is there a cure period? What are the types of things that can trigger early termination? Talking through all of these things ahead of time with your counterpart while the relationship is still good is a great way to avoid fights down the road. Fights, when it comes to contracts, leads to litigation, and litigation is extremely expensive in terms of time, money, your energy. You want to avoid it at all costs. And finally, things you can do to limit the advantages of litigation. And those are things like capping damages that we talked about. So if I know that for me to sue Jason is going to cost me more in attorney's fees than the ultimate judgment I could win against him, I'm probably less likely to sue him, right? And instead try to negotiate between the two of us. And with that, I think that's the time we had for today.
Yeah.
So love to open it up to some Q&A.
Yeah. Thank you.
Oh, and the slides will be posted on our website as well, so.
I have a question.
Yeah.
You said there were some words you were looking for when you said present assignment versus future assignment. What were those words?
So typically a present assignment is signaled by hereby. That kind of triggers that is happening now as of the date that agreement is being made. Anything else typically signals a future assignment that would occur after some events. The most common future assignment is after payment has been made, a relatively typical one. If you are a designer and you're doing design work for some folks, holding on to your IP until they've actually paid you is obviously very valuable. And so, both sides of the coin there have legitimate arguments.
All right, well, thank you all so much for being here, and please stick around. We've got a third session all about intellectual property. I think he's gonna cover trademarks, copyright, and patents. So that is starting at 2 p.m. 1 p.m. I think it's 2 p.m. 2 p.m. I think there's like a lunch break, maybe a break. Whoa, challenge. Thanks, everyone.
Thank you.